You may not have killed her, but her life left her that day.
Easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. For the whole night, I didn't even know she was alive or dead because they didn't give any information.
Not the same. People keep telling me I'm not the same. I don't feel the same.
The record in the matter 24 CF 143. State of Wisconsin versus Michael Winquist. The attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial, as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser included, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. This case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not. We move to arguments from the attorneys. I'm going to have the victim impact statement. For the record, please state your relation to this case.
My relationship to Christina is her mother.
All right, you may begin.
Well, really, what can I say? Christina has been shot. She's had to go to the doctor several times during the month. I think it was, don't quote me on this, but I think it was like 34 times out of 30 days that she was at the doctor. It's caused a huge hardship within our family. Really, what can you say? My daughter's been shot. Yeah, she may look normal, but she's not normal inside. Her cognitive ability is not there. And then you expect her to live a life, and the rest of us to live that life as well. It is what it is. The doctor's reports and everything has been there, has showed everything. She's not okay. And, let's get back to where, the very beginning of really what happened and what's gone on. And that's what I expect the council to do. Thank you.
I'm a friend of the family, also Christina's advocate. I have been here since March of 25 is when I was asked to kind of step in and help with the family. Christina did not have the ability to schedule appointments, drive anywhere. So they needed somebody to kind of coordinate all of this, and I stepped in and took that role. During the time that I've gotten to know Christina, I just love the girl. She's just a sweetheart, but I didn't know her before, so all I can say is how I can perceive her now. But she's had so many doctor visits. We had to establish primary care because she had to leave her home in Cambridge, which she lost because she didn't have any employment. So she left her home in Grantsburg and moved to Cambridge so that her son could stay with her sister. She's been to neurology. She has a TBI. She has seizures almost weekly. She had a brain bleed, which resulted in having a coil implanted. We've had psychological testing, behavioral psych testing. She's been determined that she has moderate to severe memory issues and moderate neurocognitive disorders secondary to the TBI. She's been to cardiology. She's had at least 4 cosmetic surgeries to repair the injury to the scalp. She has 2 more coming. The surgeon did make a comment that it was like putting Humpty Dumpty back together again. So that was kind of interesting because it was such a mess. The orthopedic, she has injuries to her neck and her lower back. She is now using a cane and a walker, depending on where she is. She's supposed to have a sleep study done, but she's got some trauma with that for fear of being away and being around others. She has biweekly therapy sessions for trauma, PTSD, anxiety, depression, sleep issues. Excuse me. She has 90% hearing loss, both hearing aids in both ears, and all of this is a result of the injury on May 31st. She had left Grantsburg, the place that she knew as home. She lived with her sister for a while, and her son lived with her other sister. They weren't able to be together. The home that she lost was the home that she had with her prior husband, who has since passed away. So this home meant a lot to Christina and the boys, and it's now gone. And to clean up the house, because of the damage that was done, just the biohazard cleanup alone was $28,000. That does not include repairing of the subfloor, new carpet, new sheetrock, new appliances, new flooring. That's above and beyond. Her home in Grantsburg had been robbed many times to the tune of $18,000 plus, and those charges are still pending. And that's because she was unable to be at the home. Because of the result in the loss of the home, she's incurred about $20,000 in attorney's fees, which we're not sure how those are going to get paid. Right now, her only source of income is working very part-time, and her deceased husband has a small pension. Otherwise, that is her only source of income. We've applied for Social Security disability. We've initially been denied, but we are in the process of appealing for that. She's been subject to some online harassment by the defendant's ex-wife, and also his aunt apparently made an appointment. We want to make sure that this is known to him too, and his mother. His aunt made an appointment to see Christina. She is a cosmetologist at the salon. Was very intrusive in a lot of the questions that were asked. Christina was just being very polite and very, didn't give a whole lot of information. And then as she was leaving, she turned to Christina and said, "By the way, I'm Mike's aunt," and left. That caused some serious trauma for her. No matter what happens, Mr. Winquist will be able to leave at one point and lead a relatively normal life. Christina's life has been irrevocably changed. There will be no living normal for her. She has PTSD. She has flashbacks. She has blackouts. She is fearful of being in public, or especially being around men. Her and Donovan they're doing good based on the circumstances here, but life is not normal. They're doing good, meaning that they're here physically, as to what could have happened. That's all I have for now, and thank you for your time.
And you are the victim's son?
Yes.
All right. What would you like me to know? And I'm going to say you sound a little soft-spoken, which is okay, but can you speak into the microphone and talk as loudly as you can and try and enunciate your words so I can hear them and so my court reporter can hear them?
Yes.
Okay.
So, like, I don't really understand why it's not child endangerment is added to it. Because if the gun was not jammed, I know for sure he would have came after me. Because I was still in the house. I was behind, like, one of these walls right here. I was behind one of those.
And you're pointing to the jury box?
Well, like...
So it was that high?
No. So our stairs are on the other side. And he was over here in our house by the fridge. He could have easily... Because there's no basement door to get out. So he could have easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. For the whole night, I didn't even know she was alive or dead because they didn't give any information. And then I had to stay away from my mom 3 months. 3 months. Because she had to heal. And I was living at my aunt at the time. We saw her for the first couple days. Saw her breathing tube down her mouth. She could not talk for the rest of the week after she got shot. And then the next week, she was a little bit better. And then we saw her heal and heal. She said, "I can't hear you, Donovan. You need to speak up." And then they were thinking about that she won't even remember me ever again. But that was proven that she could remember me. It was just a hard time. We're struggling to pay bills. All because of this happened. And then we get robbed like a couple nights after. And then, I don't know. And then we expect him to come back to the same community, live his life, a normal life. He can do whatever he wants as soon as he gets out. But me and my mom struggle to do stuff that we want to do. Because it depends how her legs feel. Depends how she feels that day. And sometimes she gets so scared at night that she comes in my room, makes sure I'm still there, and checks on me. That's how bad it is. That's how bad her PTSD is. I'm seeing weekly therapy with my PTSD because whenever she has a man over, I have to tense up or I have to get involved. It's just we can't live our life normal again. We can't trust any man that's in our house because we don't know what they're going to do. And yeah.
Thank you, Donovan.
Yeah.
You can either state your name for the record or you can just use your initials.
Christina Fickbaum.
All right. And I'm going to say the same thing to Donovan. Please speak into the microphone just so I can make sure that I hear everything and my court reporter can too, okay?
Okay.
And if at any time you need me to turn up the system so you can hear better, if you're missing something, just raise your hand and then I'll know that I need to turn up our audio system, okay?
Okay.
You may start whenever.
It took me a long time to decide what I was going to say, what I wasn't going to say, because...
And I'm so sorry to interrupt, but can you just, I know that this is, that you're in court and your anxiety is probably really high, but can you just speak a little slower too?
Sure. I struggle with it just for the simple fact that, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, you know, one of the big things that, you know, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that.
That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were, and struck you in the buttocks.
Like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. You know, I always tell people it's like in reference of when you blow out candles on birthday cake, that's how fast my life was gone. He didn't kill me, but my life left. And, you know, the other thing too that's pretty hard is that he could have very well taken another parent for my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess, Debbie. Can you?
Yep. I want to get one thing that I know she wants me.
Is that all you would like to say today?
She's gonna have Debbie finish for her.
Right.
Okay, and that's totally appropriate and fine. If you are going to read something, please read it slowly. Thank you.
Okay. The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There is one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen, I wasn't chosen, I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. You broke things in me you had no right to touch. I kept trying to heal with the same hands that hurt me. You didn't walk beside me, you dragged me. You weren't building a future, I was surviving a sentence. You were a storm pretending to be a shelter. You called it passion, but it was punishment. I watered dead things. I stitched red flags into rose bouquets. You weren't a lesson. You were a warning, and I just refused to listen. So tell me this, was that love or was it self-destruction wrapped in longing? Don't lie to yourself. And the worst part, I loved you deeply, but not anymore, not anymore. That's it.
Thank you. All right, you may begin.
I'm here on behalf of Christina Fickbaum. She is actually not
very much able to speak for herself. And the one statement that I would like to leave the court with more than anything is that she is asking for the highest amount of sentencing that can be provided under what he has already said guilty to. And that is it.
As the court recalls, the state is free to argue in this sentence, except that the second-degree reckless with the dangerous weapon will be concurrent to the felon in possession of firearm associated with the firearm used in it. And that will be consecutive to the felon in possession of firearm charges associated with the guns in the closet, which will be concurrent with each other. That means the state is therefore capped at 12.5 years initial confinement and 5 years extended supervision on the first cluster, and 5 years initial confinement, 5 years extended supervision on the second. Totals about a 27.5-year sentence of imprisonment, which is comparable to what DOC recommended, which was a range of between 11.5 in and 18.5 in, aggregating all their consecutive counts, and 6 to 7 out, aggregating all their ESs that they recommended. My recommendation is going to be the upper end of what I'm capped at. It's going to be 17.5 in and 10 out, which is relatively close to what DOC recommended. I'm going to start with what I call those accountability factors, because those are really fact-driven. Gravity of offense, protection of the public. So right off the bat, the need to punish and to not depreciate the seriousness of the offense is apparent. Probation has to be struck out right off the bat, even if not for the devastating nature of the injury and for the nature of the action and the danger of it, for the mere fact that he was already on probation when this happened. It would be perverse to do probation when someone commits an even worse offense while on probation. That's always a non-starter. I think it's apparent it can't be a jail sentence. It needs to be a prison sentence. It needs to be a long sentence. I thought it very significant in the pre-sentence investigation report that Michael Winquist himself said he should be sent to prison for double digits. He recommended over a decade of imprisonment himself. That itself conveys how well it is known that for the need of punishment in this case, for not depreciating the seriousness of the offense, we're talking about more than a decade of prison. It is absolutely necessary. Because this is a case where, as Christina Fickbohm described it, she talked about lifelong injury. I'd imagine it more as and I think she used this terminology in the PSI, that she feels like she's going to be a prisoner in her body for the rest of her life. The state's recommendation, 17.5 years initial confinement, 10 years extended supervision, that's not going to be the rest of Mr. Winquist's life. He'll get out almost at age 50 if the court follows that recommendation. It is more than half his life that he's lived so far. It is more than the adult life he's lived so far, but it's still less than what Christina Fickbohm is going to be facing going forward, because we know the nature of her injury. It's degenerative. It's treatable, but not curable, if that makes sense for the court, if it understands that terminology. The sentence needs to be commensurate with that injury. Proportionality demands significant punishment. I'd also like to point out that the public, as I said before, these are accountability and public policy factors. The public must be generally deterred from similar conduct to this in the future. The public needs to know, to avoid the sense of outrage that would be caused by depreciation of the seriousness of the offense, that behavior like this, that has an impact like this, use of a shotgun in a house against someone in the head, in the kitchen, this needs to be met with a massive punishment. Something less than that would, by offending the morals of the community, would affect public safety, would affect feelings of community safety and public safety. That's really what these factors relate to. Protection of the public also relates to the feelings of public safety. This is where I'm going to transition into what I call the predictive factors related to the character of the offender and protection of the public. Talk about specific deterrence, rehabilitation, incapacitation. There's a reason I outlined the facts and the conflicting information about what the cause of it was, and the fact that even, let's look at the PTSD, the sleep fighting, the domestic, the alcohol use. None of these is still a great explanation for why it happened. These are all negative factors that could contribute to something, but there's no explanation. What is the explicit thing that happened to cause him to get up, grab a shotgun, go to the kitchen, and shoot Christina Fickbaum in the head? I've alluded to in the past hearings, that was the main thing police were trying to figure out. We were trying to find a motive. We were trying to find sense in something that was utterly senseless. It turns out it was a folly. And that's exactly why I think these factors do not bode well for Mr. Winquist. This was not a violent action in regards to a hot argument. This was not, what we call a hot homicide where, hey, the child in the basement heard them having a loud argument and fighting and then escalating. This wasn't that. So we can't say it was that. Could have been any of the things I described. With the PTSD, what's even the source of the PTSD? He served in the military, but he served in a non-combatant role. Could it be the shooting that happened that was alluded to by the victim advocate? Well, Mr. Winquist was simply standing outside a bar. He was shot in the buttocks by a scope rifle for really no reason at all. He did nothing to deserve it. He did nothing to call for it. Imagine the impact on you that it would have. Just
That was an accident.
He has no idea of doing that. I'm explaining from his perspective. He's just standing in public and all of a sudden shot with a rifle. Like the impact on him in terms of PTSD on that. Could that have been the cause? Is it the alcohol? Was he in a drunken sleep, deprived of that, going through a PTS dream? Was this just an expansion of domestic that kept raising over time? A cold action that had a cold heat, if we're talking about American literature, with no planning and no end game. Was this related to stress from inability to pay the mortgage on time and the bank's actions to start foreclosure on it? Nobody has the answers to these questions. Not me, not the victim, not Mr. Winquist. Because of that, it puts us in a very precarious position when we're talking about the predictive factors. When we're talking about what sentence can the court do that will specifically deter this offender? What sentence can the court do that will effectuate rehabilitation of this offender? The PSI, the compass, says he comes back low risk. He shot somebody in the head and he comes back low risk. And that's not because DOC did something wrong. It's not because the risk assessment tools don't work. It's because we know the things that are predictive of future behavior, and they didn't predict this for this offender. Nobody predicted this was going to happen with this offender. And that's a problem. That's a problem because it makes it extremely difficult for the court to figure out what the sentence should be that would be the lowest amount necessary to specifically deter this offender. Can the court say, based on everything it has now, that 5 years or 10 years or 15? Can the court say, what is the thing that's going to rehabilitate him? With the alcohol, there's numerous references to it really just utterly ruining his life for his whole life. From starting young to getting busted down a rank in the military, to the OWIs, making him lose his right to bear arms, to this offense. As he was intoxicated, there's the blood results. It's a factor. We just don't know to the extent of how much. He's lost so much in his life to alcohol, and yet even while on probation for an alcohol-related offense, it's not deterring his behavior. It's not changing it. It's unworkable. When we look at the PTSD, there's multiple sources of it. He's aware of it. It's happening even in the description of Ms. Fickbaum about the sleeping, about the fighting in the sleep. What's he doing about it? It's something that's continuing. It's something that's worsening. It's something that's impacting the child that lives in the home, Ms. Fickbaum's child. He's been aware of the impact of the negative things on his life and not done anything to fix it. And especially with the alcoholism, We've seen a long history of inability to fix the problems on his own in the community, through his own actions, even when it's impacting others negatively, especially when it's impacting himself negatively. That being said, there is something the court can specifically deter, something that I think everybody agrees happened and it shouldn't have. Two things, really. The alcohol I described, the thing that hasn't changed to no avail over a long period of time, but the possession of the firearm. I understand that most of the guns are Miss Fickbohm's. They were the ones in the basement. However, he used those firearms and the firearm kept in the closet for protection that he himself said that is the purpose for why it's there. That's just disregard of law. That's just wanton disregard of law, especially allowing those things to be present when you are going through a period where you're just not sleeping, you're having psychological issues, when you are just on a long bender, when you're not making good decisions. The reason for the felon in possession of firearm laws is because people who get convicted of certain serious crimes, we've made the determination that they simply do not have the judgment necessary to safely have these weapons. That judgment's already been made. By law, Michael Winquist does not have the judgment appropriate for a person to possess and use firearms. Yet he's still he's demonstrating why he doesn't. It's impossible to look at this case and not think, if only he had been following the rules of probation not to drink, if only he had been following the law, none of this would have happened. I think that's really where I felt the most sense of outrage, especially from the victim when I've talked with her in our consultations. And because how could you not feel that way? I think everyone would feel that way in that situation. Because of the lack of success over time, over the military helping him with the overcoming the alcoholism, with the supervision on the OWI-4, overcoming that, with the lack of success, I think that the court needs treatment in a confined setting. That's one of the things the court has to consider. I think we've conclusively demonstrated for the things that could be rehabilitated on him, the mental health as it relates to the PTSD, the alcohol use, the sleep things, and even the domestic. These are all things that need to be treated in a confined setting, and that goes towards the sentence. But the real reason why I'm talking so much about there's not a good explanation for his behavior is because that is the sort of thing we look at when thinking about incapacitation. The reason I'm recommending a 17.5-year initial confinement sentence, even though Compass and the Department of Corrections says this is a low-risk offender, is because the community needs to be protected from him. Nobody saw this coming. If you asked the day before this of Christina or her child, is she going to get shot tomorrow? None of them would have even fathomed they would have been anywhere near that. Michael Winquist's behavior is not predictable. It's like trying to predict a wild animal, whether or not it's going to strike or not. And that's the real danger, and why incapacitation, to me, overrides even specific deterrence and rehabilitation in this case. Because Christina needs time to heal. She needs time to feel safe. That's going to take a while. So does her family. The community needs to be protected from this, because there are multiple things that need to be addressed, multiple things that are going to take years. A 20-year alcohol problem does not get solved overnight. PTSD does not get solved overnight. These dream walking things do not get solved overnight, and domestic violence does not get solved overnight. Addressing these 4 things in a confined setting will take a long time, and the mere fact that we still can't say any one of these things was the cause means the court needs to be thinking about incapacitation over specific deterrence and over rehabilitative needs. I would add that, given the nature of this offense, specific deterrence itself still does weigh in a large prison sentence. We need to specifically deter this offender from firearms and alcohol when those were 2 of the biggest driving factors to him shooting somebody in the head. in sum, to commit that offense than this. I can't think of one. I'd be surprised if the court could. On that grouping of felon in possession of firearms in the closet, the court should do the max of that as well. It is hard to imagine a worse version of felon in possession of firearm offense for an offender other than the offender shooting somebody while possessing firearms in their home. From a fact perspective, it merits a significant response. There is no obvious path to rehabilitation for the risk that this offender poses to society because of the myriad problems he has. He's known for a long time these issues make him dangerous, and he's ignored that despite legal and professional consequences. The firearms in the closet should be concurrent to each other because they're mostly Ms. Fickbaum's weapons. They are stored in the same place. It's Ms. Fickbaum's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're a parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those two things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17 and a half in, 10 out, with max on the reckless, max on the felon possession of firearm, those concurrent to each other, and then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
Thank you. Mr. Harrington.
Thank you, Judge. Before I analyze pursuant to the McCleary factors, I want to add a little more context to the circumstance. And in the course of adding to the context, I must make reference to Ms. Fickbaum. I want the court, I want Mr. Vitt, Ms. Fickbaum, and all of her friends here to understand that I am not in any way blaming Ms. Fickbaum. She was the victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. Mr. Vitt suggested that the circumstances of that day were not predictable. They were not predictable that day. But the facts, the background and the facts made this tragedy absolutely predictable. First of all, let's look at the circumstances of Mr. Winquist and Ms. Fickbaum. They were engaged in a presumably romantic relationship. Ms. Fickbaum's statement emphasizes that in retrospect, it wasn't romantic, it was abusive. Mr. Winquist has told me that, in fact, he considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm going to still be in victims' rights compliance.
He needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take,
She doesn't want to hear this. Yeah, that's it.
okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you. He wore the wedding ring in jail for months. I can't tell the court when he took it off. He considered that they were married. They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the plea, or the PSI, he gave her $75,000 because he thought they were going to stay a couple. He needed expenses, the money to pay some expenses in the house, and they needed to make some repairs. They lived together. They shared the living expenses. They vacationed together. They enjoyed each other's company. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. The discovery reflected that when the month before May 31st of 2024, there had been flirting by email between these two. But there's one other thing that they did together that made this tragedy predictable. Right? Right. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Tickbone's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. We in the court system far too often observe the tragedies that result from increased alcohol consumption. As people continue in that process, they drink more and more. They make poor choices. They engage in riskier behavior. If they continue with that risky behavior, usually that consumption leads to a tragedy, both in their lives, but oftentimes in others' lives that are just innocent bystanders. My example is the instrument of the tragedy in most instances is an automobile. This instance, the instrument was not an automobile, but it was a firearm. A Remington 870 12-gauge shotgun. So I also contend and argue that in this particular instance, the tragedy was predictable because of the circumstance, but the tragedy was also predictable when we look at the instrument that was used. During the search of the house after the crime, law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there. They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. That was Christina's handgun. They discovered in the basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded .22 Marlin rifle and a loaded .22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. But the date was May 31st, 2024. All those facts came to head, resulting in this tragedy. Michael Winquist and Christina Pickbone had consumed alcohol beverage during the afternoon, and I'm making these factual statements on the basis of the discovery. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. I don't remember where I found that, was in my notes. I rather suspect that I got that number from some electronic discovery that I received. They consumed the alcohol. They visited a neighbor. Christina was driving the motor vehicle. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. He is the victim of this horrendous tragedy, no doubt. I urge the court to adopt the Department of Corrections recommendations, with the exception that counts 3, 6, 7, and 8 be consecutive to consecutive counts 1 and 2, but concurrent with each other. Judge, I started this conversation, this argument, with noting the tragedy. And it truly is a tragedy. Could it have been avoided? Yes, but it would have taken Michael to recognize his substance abuse did not. And we're here. And that's what this is for. The final note, Michael paid the $10,000 initial payment on restitution a couple months ago. He tells me he sent another check for $2,582.23 to the court just within the last couple of days. The restitution request has been paid.
It has been confirmed that that has been paid. So what is the total initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial confinement, 4 years ES. Actually, 10 and a half years, Judge. I'm sorry.
Okay.
6.5 on count 1, initial confinement. 2 on count 2, initial confinement. 2 on counts 3, 6, 7, and 8. Count 2 consecutive to count 1. Counts 3, 6, 7, and 8 consecutive as to counts 1 and 2, but concurrent with each other. We believe that satisfies the needs and is appropriate. I have calculated his credit days through today at 565 days, including today. Thank you, Judge.
564 because you don't count today.
564.
Mr. Winquist, I'm now going to turn to you and give you an opportunity. Actually, I'm going to wait to see if the victim would like to come back in. All right, the victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know. This is where you can state anything that you've heard that's been inaccurate, or you can go into more depth about things that have been argued or stated or that are in the facts in this case. This is where you have the ability to show any remorse or anything of that nature. You do not have to give a statement today, but it is your only opportunity. If you are going to read something, please read it slowly, enunciate your words, and please speak into the microphone.
Okay.
You may begin.
Thank you.
And can you please move the microphone closer to him?
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. I would also like to apologize to Donovan. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that I've had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
Is that all?
Yes, Your Honor.
Due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety. It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is, but I don't rely heavily on the compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other, any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring, and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. And stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have, serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. And the fact that you were convicted of an OWI fourth offense of felony, you were told you were still on probation. You were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's a miracle. And thankfully to all that believe in higher powers, is a miracle that Ms. Fickbaum is alive. But what she suffers from daily is worse than death. The court believes that the sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in alcohol consumption that day, and she may have been extremely intoxicated as well, she in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. With count 1, the court is going to sentence you for the underlying second-degree reckless injury, 7.5 years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12.5